Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Hello. Happy Thursday, everybody. How's it going? I hope you guys are having a great week so far. I know that it's been a while since we did a version of Latest in the Law. It's had several different iterations. This is, I think, my very first time doing a Latest in the Law just completely by myself. It's where I like to, once a week, take several cases, talk about some updates in some cases that are in the news or otherwise developing. And kind of what I want to start to do is follow a number of cases through their progression through litigation. So, of course, as you guys are aware by the title of this live stream and the thumbnail, we are going to be talking about the latest in the Marilyn Manson case and in the Vanessa Bryant versus LA County Sheriff's Department. So I know that I'm still very much catching up on the Manson case. We're going to talk about basically by the end of this live stream on the Manson case, we're going to come to where this case really sort of is procedurally and what we're going to be looking forward to, what sort of legal arguments they're going to be getting into. And yeah, so we'll be mostly caught up. I'm still going to do some dedicated videos talking more in depth about the anti-SLAPP motions and some of these other motions to get into detail. But this is more just about sort of like the overall landscape of what is going on in this case. Where is it procedurally? Where is it in terms of like where that kind of litigation drama is? Same thing with the Vanessa Bryant case. So I did not actually realize when I was talking about the Vanessa Bryant case that there's actually another case just like it coming out of the same incident, coming out of the same photos being shared and whatnot, or I guess allegations of photos being shared, I should say. So we're going to talk about that case and how the two are sort of intersecting here. So, let's see here. Okay. So yeah, so I know that a week ago, folks on Twitter were all ablaze on the Manson case, talking about the declarations that came out. There's a lot of fiery information. People talking about declarations from Illma Gore's twin sister, Brighton Gore, talking about the drafting of the FBI letter. She says that she saw stuff. The issue of whether Brian Warner, aka Marilyn Manson, is under FBI investigation. There was a declaration by his attorney Blair Burke talking about how they had talked with the individual who was named on that FBI letter, and they wanted to depose that FBI agent. And the facts surrounding the groupie film. There was also a declaration by Paula Weiss, the actress that was in that video or in that movie or in that film. So there's been a lot of information that people have been talking about, and I'm going to get into those declarations more in detail, but not today, because like I said, I want to get into these sort of different arguments that have been going on, talking about the what was I going to say? Like I said, more of the procedural drama. Now, I know when I say procedural drama, that seems like kind of a little bit of an oxymoron, because when people talk about procedure, their like eyes are going to glaze over for a lot of people. But this is where a lot of the drama happens in litigation, is these struggles of like who's putting pressure on whom with different deadlines, different hearing deadlines, motion deadlines, and who's going to ask for more time for different things. Why are they asking for more time for different things? There's a lot of things that happen in between these like big moments where it like some sort of like fiery information gets leaked out to the press. So we'll talk about a bit about that. But first, we're going to talk about the Vanessa Bryant case, because that one is interesting. And like I said before, that is a case that is going to trial in mid to late August. So it's coming up very quickly. And if you aren't familiar with this particular case, I did a live stream last week going over the complaint filed by Vanessa Bryant in the case. And if you're not familiar with the case and you want to go and watch that, I should have linked in the description. But it is just a disclaimer. It's a very, very heavy complaint. There's very heavy allegations. It is coming out of the helicopter crash that killed Kobe Bryant and Gianna Bryant and a number of other individuals that were on their way to a basketball tournament for the girls' basketball team. And gruesome way of dying. And it's not about the wrongful death claim. So it's not, the litigation that we're talking about here is not about what caused the helicopter crash. Was there some sort of malfunction? Was there something that the pilot did wrong? What resulted in this? What this particular litigation is about the photos that were taken of the crash site and that were allegedly subsequently then shared. And then there's an alleged cover up on top of that, according to Vanessa Bryant's complaint. And it's a lot. It's a lot. I mean, on top of that, I mean, even just beginning, and this is not necessarily the sheriff the sheriff department's fault, but I mean, right off the bat in this case, when you read the complaint, you have a lot of sympathy for Vanessa Bryant, because you learn, like, the first thing that you learn is that she learned about the death of Kobe and Gianna from the news, from the press. She didn't learn from the sheriff's department or from the coroner or anyone like discreetly. She was like one of the last people to find out about it, which is a terrible. I mean, no one wants to have that. No one wants to have that news ever anyway. Like, there's no good way to receive that. But it seems like in terms of like the scale of like bad to worse, like that's probably the worst way to find out. So it's a case that has a lot of sympathy for all of the plaintiffs, whether we are talking about Vanessa Bryant or whether we are talking about the other plaintiff in this particular case that is a surviving husband. So what happened here is that there was a decision. So there was a decision by the court to consolidate the two cases. So let's first go into, let me pull up here. Okay. I had to upload these to StreamYard. I hope you guys can see them. I know that the writing is a little bit small here, but I can't zoom in any further because I had to upload them. But okay. So, okay. Anyway, so what happened here is that the court said on July 8th, I believe, there was a hearing where the court basically told the parties in the two different cases, all of them, saying, hey guys, I want to see some briefs on whether or not we should consolidate these cases, because they seem like, I mean, they all come out of the same sort of incidents, the same, helicopter crash, the same, not specifically same photos. I mean, because they would be different images of different individuals, like allegedly, but the same defendants in the case, same witnesses, there's a lot that's the same here. And so the judge basically said, hey guys, let's see if we can create some judicial economy here and speed things up and not waste resources of the court and of the parties and all of the different, entities that are involved here. And let's see if we can consolidate them and try them all at the same time. So basically, they all had to turn in motions for it. So first came in was the defendant's motion coming from all of the defendants, but basically what I'll say is LA County is how we'll shorten the name, because it's, as you can see here, it's County of Los Angeles County Fire Department, Joey Cruz, Rafael Mejia, Michael Russell, Raul Versales, Arlen Cahan, and Tony Imbrenda. So what they basically argued, I'm just going to do the introductory arguments because I don't think we need to go through the entire argument here. But basically what they said was the LA County Sheriff's Department, or LA County, I should say, they basically said, no, we don't want to consolidate the cases because we think that the jury is going to get confused somehow. Let's go through specifically what they said. They said the Bryant and Chester cases arise from the same tragic incident, but they are two different cases. Consolidating them for trial would create jury confusion and risk a fair trial. The court has broad discretion to deny consolidation when the benefits are outweighed by the risk of jury confusion and prejudice. Vanessa Bryant's and Christopher Chester's cases are materially different. Chester cannot point to any evidence of photos depicting his loved ones. Unlike in the Bryant case, where witnesses have testified about pictures of Kobe Bryant, no witness has ever testified about seeing a photo depicting Chester's family members. This is a significant gap in Chester's evidence, making it unlikely he can prove public dissemination and thereby establish a violation of the 14th Amendment under Marsh. One problem for the for LA County here is that arguably the reason why there's no photo evidence, or at least one of the arguments that the opposing side, that the plaintiff side can make in this kind of a case, is that if you guys went over the complaint with me on this one, you know that the LA County Sheriff, Sheriff Villanueva, asked all of the individual officers who had photos on their phones when they found out about this whole thing, and then they got a lot of pressure from the outside once it sort of leaked out that there was sharing of these photos, that he told everyone, hey, delete your photos and you won't see any sort of repercussions, right? Like you won't get fired or whatever. So everything got deleted. And they have since also, I mean, that's part of their legal argument here, is that they, at least in the Bryant case anyway, is that they said that they've gone through this whole process of deleting the photos, and they've done forensic metadata analysis and all this kind of stuff, and that they're like, so yeah, everything's gone, everything's done, so there's no harm here as a result. That's one of the arguments that they're making in this case, which I don't know that I particularly agree with that. Yeah. So but anyway, yeah, and guys, I'm sorry, I know that the text is a little bit small here. But unfortunately, in order for me to have this show up at all, I had to upload it. So I don't have a way of zooming in, unfortunately, unless, let me see here. Or I could try full screen layout. No, it's the same size. It just moves over. Hey, Kurt. Hey, Uncivil Law. Welcome to Bike Club. Thanks so much for becoming a YouTube member again. I know you got booted out along with everybody else, and I'm really sorry about that. But I'm happy to see you back in here. Okay, so alrighty. Let me continue reading here. So I've got, and just so you guys know, I've got 2 documents that I had to upload. The rest of them I'll be able to share a bit more normally. So just bear with me for a little bit longer. Given Kobe Bryant's worldwide recognition, Bryant's case is distinct. Chester should not be permitted to ride Bryant's coattails and benefit from critical evidence that only pertain to Bryant. Ooh, I wouldn't have used that choice of words, personally. Chester has shown his propensity to do this in nearly every pretrial filing, and again at the July 8th pretrial conference. When the court, let me see here. where I lost my spot. When the court asked whether there is any evidence of dissemination of pictures of Chester's family members, Chester's lawyer dissembled. He conflated the evidence in the two cases and thereby demonstrated the substantial prejudice to the county if the cases are tried together. As explained below, there are different facts and witnesses in play. The party who stands to benefit from consolidation is Chester. Given the celebrity of the Bryant case, there is a real risk that the jury will impute evidence regarding Bryant to Chester. In the interest of fairness, each plaintiff should have to prove his and her distinct claims and injuries at trial. This is a most unusual case. Kobe Bryant was a revered icon. Sorry. The case brought by his widow, Vanessa Bryant, is highly charged and has already received a great deal of media coverage. The Chester case should be dealt with alone on its merits and not bootstrap the Bryant case. Basically, what they are worried about, I think, is the fact that this case is getting a lot of publicity. I think that maybe they don't necessarily want folks to know about this other case. But the issue with it is, I would imagine that the photos coming out about Kobe Bryant probably also then alerted the other family members of other victims about these photos being taken. And so they probably had a lot of interest as well in this particular issue. And the thing is that even if there are no photos and they don't have like for example, in the Vanessa Bryant complaint, we went over where they said that there is actual surveillance footage of one of the deputies actually in a bar showing his phone with the photo and zooming in to the photo to show more detail. There's actual surveillance footage of that. If there hadn't been surveillance footage of that, I mean, who knows, right? Like who knows what would have happened there. So it seems like Kobe Bryant's case has the benefit of some of this like other circumstantial evidence showing like, yeah, these photos did exist. Even if they don't exist now, they definitely did. And they were shared by these individuals to other people. And they've kind of been forced to admit it at this point. They've admitted to a few of these instances, or at least one or two of them they've admitted to. And the problem for LA County is that a jury could then look at that and say, okay, well, I mean, like you say that no one shared any photos of Chester's wife or daughter, but who's to say that you're not lying about that? Because the problem for LA County is that they've already been shown to have lied in this process of investigating this issue, because it's bad. It's bad, right? So I can understand why LA County did not want to have these cases put together. And I can understand why Chester and Bryant would want to have their cases together. So, alrighty. So let's see here. Do we need to go into more detail here? So their basic arguments were for why they shouldn't be consolidated at trial are: there's no evidence of photos depicting Chester's loved ones. They said that it would be misleading and prejudicial for the same jury to hear evidence of both Bryant's and Chester's emotional distress. And then they say that the county will be prejudiced if the jury imputes Bryant's social media evidence and witnesses to Chester. And finally, they say that Bryant and Chester have opposite positions regarding evidence of their settlement with the helicopter company. So all of these reasons were reasons why they said they didn't want to have them put together. That is that one. Now we go to Plaintiff Christopher Chester's brief in support of his consolidation along with Vanessa Bryant. So here's the first page. Alrighty. Here it says, Plaintiff Christopher L. Chester, plaintiff, respectfully requests that his case be consolidated for trial with the case entitled Vanessa Bryant, etc. versus County of Los Angeles et al. Plaintiff Bryant also has requested consolidation of the two cases for trial. The two cases involve common questions of law and fact. Each case arises from the same helicopter crash in Calabasas, California on January 26, 2020. Each case proceeds to trial against the same defendants: the County of Los Angeles, the Los Angeles County Sheriff's Department, the Los Angeles County Fire Department, collectively the defendants. Both cases will proceed to trial on the same cause of action, violation of the 14th Amendment, pursuant to Monell v. New York Department of Social Services. Both cases involve nearly identical witnesses and exhibits. Consolidation of the two cases will avoid the substantial burden, inconvenience, and expense that separate trials would impose upon the court, the parties, and the numerous percipient witnesses who would be required to testify twice about the same matters if consolidation is denied. Defendants neither deny nor dispute any of these facts in their consolidation memorandum. They cannot object because defendants themselves have sought consolidation of the cases. In a letter to plaintiff's counsel dated March 4th, 2021, defendant's lead counsel wrote, "Please let us know whether you will stipulate to consolidation. If not, defendants intend to file a motion to consolidate the three cases." Declaration, this is according to the declaration of Jerome M. Jackson, Esquire. On March 19th, 2021, defendant's lead counsel wrote a second letter to plaintiff's counsel. "We have three related cases pending in front of the same judge. They all concern similar underlying facts and legal arguments and are set for the same trial date. We believe these cases are ripe for consolidation and that doing so will conserve party and judicial resources. Please let us know if you will consent to a joint stipulation consolidating the actions by March 23rd, 2021. If you are not willing to stipulate to consolidation pursuant to Local Rule 7-3, please let us know your availability the week of March 22nd, 2021 for a meet and confer conference regarding a motion to consolidate the three related cases." So basically, they had previously said, "Hey, let's consolidate." And by they, I mean the LA County. And then now they're saying, now that they are right before trial, they're saying, "No, we don't want to consolidate because we're worried that doing so will like bias the jury because it's Kobe Bryant." Basically, that's what it sounds like to me. They're worried about the bias. They're worried about Kobe Bryant's case helping out Chester's case, really, where it seems like back in March 2021, which was probably, I think that's like right after this case was filed because he died in January 2020, actually. So maybe that wasn't right after this was filed. Hang on a sec. Let me take a look at this. One second. Let me just double check on the exact date that this was filed because it's going to bother me if I don't double check it. Yeah, okay, so the first amended complaint was filed on March 17th, 2021. So there had already been a complaint filed before, but I never downloaded the complaint because it isn't exactly necessary for my purposes. But the first amended complaint is the one that's basically controlling here. So basically, in other words, it seems like that's when they were probably trying to get going on consolidating all of the different cases to make things easier on their department, because that probably would have streamlined things for their legal expenses, their attorney's fees, all that kind of stuff, rather than having to manage three different dockets and three different cases. But now that they are right about to go to trial, it's a little bit of a different story, it seems like. Okay, let's continue. When plaintiff Chester's counsel agreed to consolidation of the cases, defendant's counsel thanked him for his cooperation. Now, however, the defendants have turned surly after both plaintiffs requested the same consolidation, which lead defense counsel previously had sought. The defendants brazenly accused plaintiff Chester of trying to ride Bryant's coattails in order to bootstrap and piggyback the Bryant case. Like I said, I would not have called it that. I wouldn't have used those words necessarily, because in litigation, you can use a lot of strong language. You definitely can. But in a case where We're talking about filings that ultimately are going to make it to the press, right? Because we're talking about the Bryants here. And this is also just the facts of the case itself are pretty terrible. So this is a case that has a lot of eyeballs on it. I don't know that I would call that I would say that a grieving widower is riding the coattails of a grieving widow. It's I don't think that um that's the best look, personally. It's not the approach that I would take if I were drafting the LA County's motion. Okay. So, oh, whoopsies, excuse me. And oh yeah, so in case you guys are trying to follow along, if you are not with me here, I'm at line 17. So I know it's kind of tiny. Sorry, guys. I'm going to make sure to have this set up better next time. Okay, starting at line 17. But the memorandum simply fails to provide any valid reason for denying the consolidation, which the defendants themselves previously had sought. The defense primarily relies on a disputed issue of fact, whether there is evidence of photos depicting plaintiff Chester's loved ones. The defense, however, fails to explain how or why a disputed factual issue has any bearing on the issue of consolidation. While the defendant's deliberate destruction of the photographic evidence has made it more challenging for plaintiff Chester to prove the existence of those photographs, the task is not impossible. The admissions and conduct of the defendant's own employees demonstrate that photographs of all the decedents were taken in the morning of the accident and later shared. The defendants next argue that the jury somehow will be confused by the two plaintiffs' claims for emotional distress or by plaintiff Bryant's involvement with social media. They make this claim despite their own exposition of the clear distinctions between each plaintiff and his or her claim. The distinction, which the defendants themselves have spelled out in their memorandum, dispel any concern that a jury somehow would confuse Vanessa Bryant with Chris Chester. Finally, the defense makes the erroneous claim that plaintiffs Bryant and Chester have taken inconsistent positions regarding the admissibility of evidence concerning another unrelated lawsuit. This is simply not true, as both plaintiffs have objected to the introduction of exhibits related to that unrelated lawsuit. More importantly, if the court gives an anticipated jury instruction concerning that other action, the issue will become moot. So that is their basic argument. And then they go on more, go through their legal argument, and then they basically make these main points. They say, contrary to defendant's argument, there is evidence of photos depicting Chester's loved ones. And then they say the defense memorandum inadvertently proves there is no realistic possibility that plaintiff Chester's emotional distress claims will be confused with plaintiff Bryant's claims for emotional distress, probably because of the fact that they're very different individuals and have very different lives. Then they say there is no reasonable possibility that a jury will impute Bryant's social media and witnesses to Chester. And finally, they say Bryant and Chester have allied positions regarding evidence of their settlement with the helicopter company. So basically, they dispute everything entirely. Now, the docket on Pacer, which is where you can find filings of for federal cases such as this one, does not have anything yet of an order from the court on this particular issue. However, their PR firm has the PR firm that is working with the firm that is representing LA County has reached out to me, and they sent me an email basically asking if I'm going to be talking about this particular issue, and if I am, if I can include a statement from Mira Hashmal, partner at the Miller Barondis law firm and lead counsel for LA County in this litigation. She says, we are not surprised Judge Walter decided to try the Bryant and Chester cases together, but he confirmed that each plaintiff must meet their separate burden of proof at trial. And while plaintiffs want to argue there was a widespread custom and practice of improper sharing accident photos by first responders, the fact is there is no evidence of it, and they won't be able to prove it. It's also significant that Judge Walter did not find the sheriff did anything wrong when he gave the order to delete the photos so that none of them would become public. And in fact, it's been more than 2 years and no county photos have ever been made public. So, I mean, a few points there. I mean, that the issue of whether it's a widespread custom and practice of improper sharing of accident photos by first responders, that is one of the disputed issues that they are precisely litigating over in this case, in both cases. And I mean, that's how they are trying to get the entities, LA County Sheriff's Department, LA County Fire Department, how they are trying to get them on the hook for liability for the sharing of these photos is basically by saying, you guys should have had a policy and practice in place where people are explicitly supposed to not take photos that aren't necessary for the purposes of investigation. If someone is investigating what happened and that's part of their job duties, by all means, take the photos that are required in order to do your job. But if you're not necessary, if you are someone who is just directing traffic, making sure that crowds don't come to the site and start peeping around, you are not someone who should be taking photos at a crash site. And what has come out is that they didn't actually have a specific policy around this, even though this has been an issue of, I mean, this has been something that has been, I mean, people have been curious about these kinds of things since, I don't know, the beginning of humanity, you could say. And in particular, in a place that is so surrounded by celebrity, or I guess I should say, so saturated with celebrity, these things happen from time to time. You have accidents where some celebrity dies. Paul Walker was one, right? He died in a car crash. So of course you're going to have more curiosity even than normal, which is why you need to have certain policies in place so that people can be professionals and not do you know, not do this essentially. So the fact that they have since put policies in place is not an indication of liability before. You can't necessarily use that as evidence of liability to say like that they owe or some sort of culpability, because you can't look at that and say like, oh, you know, they knew that what they did was wrong, and so that's why now they have a policy, because the law likes to see businesses and entities and other entities basically, or individuals even, preventing further liability in the future, preventing future harm. So okay, now so it looks like these two cases are going to be consolidated together. And so that'll be interesting, even more so, to see as this proceeds towards trial. As of yet, I still don't see a firm date on when the trial actually is going to be, but it looks like it is somewhere between mid to late August. So very, very, very interesting. Okay, now let's turn to the Manson case. Alrighty, let's see here. Can remove that. And I can remove that. Let's see here. Okay, so the Hey Manson cases, how are you? Happy to see you here. So, okay. On this particular topic. So, like I said before, there were declarations that came out that everybody's been talking about. Brighton Gore's declaration about witnessing the drafting of the FBI letter, and then there's the declaration about the FBI agent saying like, "Hey, like we need more information from this individual." And so people were talking about the information that was coming out of these declarations, but what I'm going to be talking about is the purpose of these declarations. Like, why were they filed in the first place, right? So in order to really explain that, I have to sort of go back into the what's happened in the docket before this point, just very briefly. So as everybody knows, back in March, Brian Warner, also known as Marilyn Manson, filed the initial complaint against Evan Rachel Wood and Illma Gore. Normally, what happens after a complaint is filed, some sort of a response has to be filed by the defendants, and each of them have to file their own, or they can do a joint one. Anyway, they both have to respond in some fashion. So either by filing an answer or some kind of a motion to dismiss it in some form or another. Now, in California state court, a motion to dismiss is called a demurrer. Demurrer. Funny fact, I know I've mentioned this many times on the channel, but if you haven't heard me talk about demurrers yet, it's spelled Demurrer. And for whatever reason, for the longest time, maybe because I didn't go to law school in California, and so this was a new term for me, and I had always seen it, I had never heard it, so I kept wanting to call it demurrer until my boss, after I used it maybe 5 or 6 times, my boss asked me, he was like, do you know it's actually demur? I was like, oh, I've actually been using this. Okay, I've definitely been saying this word wrong this whole time. Anyway, so it's demurrer, not demurrer. Like pinkies out, demurrer. Anyway, so what happens is the defense has to file some sort of a demur or an answer, or in this particular case, what happened was a special motion to strike, also known as an anti-SLAPP motion. What happens when there is an anti-SLAPP motion is it's a little bit different than other like a motion to dismiss, answer. What happens specifically with an anti-SLAPP motion is it's a very serious it's a motion that's taken very seriously in California, because it basically is saying that the plaintiff is abusing the litigation process and therefore infringing on my First Amendment rights. So California takes it very seriously. There's a whole like procedure that's very specific to California for anti-SLAPP motions. So basically what happens is the plaintiff is not allowed to move forward with a litigation at all as soon as there's an anti-SLAPP motion on the docket. Because normally what happens when as soon as the plaintiff files a complaint, they serve it on the defense, they can pretty quickly start to send them discovery requests and say, hey, I've got all these interrogatories to ask you. These are open-ended questions. I've got a whole list of them, and you have 30 days to respond. Hey, I want all of these documents from you, and you have 30 days to respond and to provide all of these documents. And I also have some yes/no questions for you. So and then it can be very, very burdensome very quickly, especially if the plaintiff is really on it. But the thing about the anti-SLAPP motion is that gets frozen. They're not allowed to ask for any of that information. They're not allowed to engage in the discovery process. So what happened here in this particular case is there was a status conference on July 6th, I believe, where they were just doing a normal case management conference, which happens in litigation. Like as you're going through, courts will say, okay, there's what's on the docket next is the litigation proceeding. You have it throughout the whole litigation periodically. So what the court said was, okay, so I see these anti-SLAPP motions that have been filed, and I see that you guys got hearings all the way out in December and January, because when you file a motion like that, especially if it's a motion that needs to be heard, you need to have a hearing for it to maybe have some oral argument on it before the judge makes a final decision. You have to set a hearing for it when you file the motion as well. And because of how backed up the courthouse is, they were only able to get most hearing dates in December and January, respectively. So Evan Rachel Woods was going to be in December, Illma Gore's was going to be in January because she had filed her motion a little bit later, like a month after Evan Rachel Wood had filed hers. So the court decided on July 6th, you know what? We're going to move this back up actually to August 18th for Evan Rachel Wood's hearing and September 13th for Illma Gore's hearing. So, all right, Marilyn Manson or Brian Warner, you need to get your opposition filed in a certain amount of time for this, and then they have a chance to file a reply. It's basically this tennis match that goes back and forth in motion papers between the two sides before they have their hearing, and then the judge gets to read everything, look at all the arguments, and then make a decision. So there's certain deadlines that have to be met along the way before that hearing happens. When the judge moved up the hearing on July 6th from December to August, basically said, all right, Brian Warner, you have a few weeks to get your opposition in. And the thing about the anti-SLAPP motion is that I'm going to get into like the detail of the arguments, but the thing about the anti-SLAPP motion is that it's basically a two-pronged test that happens in any kind of an anti-SLAPP argument. Basically what the moving party, the defendant in here, in this particular case, what they have to show is two things. First off, they have to show that number one, there is a particular like right that's being infringed with a particular allegation. Basically saying that the allegation against them falls within a protected activity. It can be a filing. It can be a statement that was made in a filing, a statement that was made in a legislative hearing, or what have you. There's a whole list of different types of activities that are considered protected activities under the First Amendment. So if the allegation against the defendant falls under one of those, that's prong number one. They have to show that. Then prong number two is that they have to show that the defendant is the exact standard escapes me. The wording of the exact standard escapes me at this moment, but basically saying that there is no possibility of the plaintiff proving their case as to that particular allegation. So as an example, in Evan Rachel Wood's argument, she has, as to the FBI letter, one of her arguments is that she says that the FBI letter was drafted for purposes of use in the parentage proceedings about the custody battle between her and Jamie Bell for their son. And so she says that she says, number one, the FBI letter is real. Number two, she says that that even if it was not real, then it was, it was drafted for purposes of use in a litigation proceeding, and therefore is a protected activity. Arguably, that is probably true. Now, number two of that argument has to be that Brian Warner has no way of winning as to that particular allegation. The issue of for that specific allegation about the FBI letter, I think Brian Warner is likely to come back on the anti-SLAPP opposition to say it wasn't about the parentage proceeding. It was about the fact that you were sharing this letter to other individuals that had nothing to do with the litigation. Anyway, we'll get into those arguments, but they have to meet those two elements. Because of that second element of an anti-SLAPP motion, Brian Warner arguably does need to have access to some kind of information to be able to make some kind of a case in the argument for purposes of the anti-SLAPP. So going back to the ex parte application, what happened was last week, what day was this? This was on the 20th. So yeah, almost exactly a week ago, he filed an ex parte application for order shortening time to hear plaintiff's motion to conduct limited discovery pursuant to Code of Civil Procedure section, it's basically the anti-SLAPP statute, and request a continuance of defendant's motions to strike to permit such limited discovery. So basically what he was asking for was the ability to, first off, he was asking for a very quick hearing because he said, hey, this is super urgent. I need tomorrow. I need to talk to the judge tomorrow. And yeah, opposing counsel, I've given them notice, et cetera, et cetera. We need to decide this very quickly. That I need, number one, to be able to push back the anti-SLAPP motions so that I have time to work on my response for that. Number two, more importantly, even before that, I need the ability to have some limited discovery requests of the opposing side so that I can put together my case for purposes of the anti-SLAPP motion. Does that make sense? I hope it makes sense to you guys. So basically what he's saying, he's like, okay, in order to do the anti-SLAPP opposition, I need, first off, to move back the hearing date a little bit. And on that, even before that, I need the ability to request this information from the opposing side. I want to depose Evan Rachel Wood. I want to depose Illma Gore. I want to do all this stuff. So and not just I want to, but I need to. And everything that I'm going to ask is limited to the specific questions that need to be answered in order for me to be able to properly oppose this particular motion, which has been filed by the other side. He does have a right to respond. And he to respond in a way that his hands aren't tied behind his back. So what happened first was the judge has to make a series of decisions here in this particular like cluster of issues, right? So first issue is was the judge going to grant the ex parte application, basically saying, yes, I will allow you to argue this issue in front of me. And that was decision number one. Was the judge said, okay, yes, January 21st, you can come and argue and we'll talk about all of these issues. Decision number two was the court said, okay, the hearing that is set for August 18th for the anti-SLAPP motion is going to be moved back. Now, instead of that, on August 18th, 2022, so same day that you guys were going to have a hearing on the anti-SLAPP motion, that has been pushed back. On this hearing date, you still have a hearing, but it's on a different issue. And that issue is going to be the motion to conduct limited discovery. So that's what the judge decided at this particular point, was that the not to say that the judge has decided that the that Marilyn Manson can actually what was I going to say? The judge hasn't decided yet on whether or not Brian Warner can depose Evan Rachel Wood and Illma Gore and request all this information from them, but basically said, okay, I'll give you an opportunity to be heard out on this particular issue. So in other words, August 18th now is the date for the hearing on the discovery issue on whether or not these other depositions and requests and stuff can be made against Illma Gore and Evan Rachel Wood. And then a month after that is when they have on the calendar for the anti-SLAPP motion. Now, if you are looking at that and saying, wow, like let's say August 18th, Marilyn Manson wins and says and is able to do this discovery, and then a month later they have a hearing on the anti-SLAPP motion. That's not a lot of time to do depositions, get responses. That's 100% not enough time to get this information back before that hearing date. So basically what the court did was what they're setting the hearings as early as possible. And what's going to happen is if on the 18th, the judge decides, okay, you can conduct all this discovery and whatnot to collect this information from the other side, then what the judge will do is actually delay that September 13th hearing further back to give them time on the particular on discovery. So, but basically the reason for holding the September 13th hearing date for the anti-SLAPP issues is in case Brian Warner loses that motion, in which case the court will say, all right, now you need to turn in your opposition motion within a certain amount of time to give the other side an opportunity to respond. So, okay, let's go through, now that I've gone through basically that whole like explanation. Hi, Indy. So now that I've gone through that whole explanation, let's go through the papers on this so you guys can see exactly what the arguments were. Okay. All right. Okay. All right. So as you can see, it's ex parte application for order shortening time to hear plaintiff's motion to conduct limited discovery, et cetera, et cetera. So um this is the ex parte application that was filed by Brian Warner, aka Marilyn Manson. Okay, this is just the introduction here. Let's see. Okay. Plaintiff Brian Warner, professionally known as Marilyn Manson, requests an order shortening time for the court to hear this motion to conduct limited discovery pursuant to Code of Civil Procedure Section 425.16G, anti-SLAPP statute, and requests for a continuance of defendant's motions to strike to permit such limited discovery submitted herewith. Good cause exists for the ex parte relief sought. Defendants Evan Rachel Wood and Ashley Gore, aka Illma Gore, originally noticed the hearings on their two separate but overlapping anti-SLAPP motions for December 2022 and January 2023, respectively. On July 6, 2022, the court sua sponte, meaning the court of their own, sua sponte advanced the hearings on these special motions to strike to August 18th and September 13th, 2022, making Warner's first opposition due within 4 weeks on August 5th. Under the original schedule, Warner intended to seek leave from the automatic discovery stay imposed when the motions were filed. So discovery stay meaning what I said about the discovery being frozen. That's what that means. In order to obtain specific admissible facts within defendants and three non-party witnesses' control needed to establish his prima facie case and defeat the motions. Under the new schedule, however, the court cannot hear a motion pursuant to Code of Civil Procedure Section 425.16G on regular time as it could before. Absent an ex parte order shortening time to hear Warner's request, Warner will be immediately and irreparably harmed if he must submit his oppositions to defendants' motions beginning on August 5th without the benefit of the very discovery California statutes and published appellate opinions authorize and encourage granting in this context. Alrighty. So then they say the court is authorized to shorten time to hear Warner's request for limited discovery, and ex parte relief is warranted under the circumstances. Code of Civil Procedure Section 425.16G provides that while an anti-SLAPP motion automatically stays discovery, it freezes it automatically, the court on notice motion and for good cause shown may order that specified discovery be conducted. Basically saying if you have good enough reasons, the court will allow you to do some discovery. The court's ability to lift the stay counterbalances the procedural requirement of forcing a plaintiff to make an evidentiary showing without the benefit of discovery, given that the anti-SLAPP statute seeks to strike only frivolous causes of action. And then it cites to Schroeder v. Irvine City Council. Denial of discovery can adversely affect due process rights by placing the burden on the plaintiff to show a prima facie case without permitting the collection of evidence needed to satisfy that burden. Yeah, basically saying there is a burden on the plaintiff that is placed here with an anti-SLAPP statute that they need the ability to present some kind of evidence in order to meet a burden. Code of Civil Procedure Section 1005 prescribes the times for written notice of motions and for the service and filing of supporting and opposing papers. Section 1005B provides that the court or a judge thereof may prescribe a shorter time than otherwise required in Section 1005. To that end, California Rules of Court Rule 3.1300B states that the court on its own motion or on an application for an order shortening time supported by a declaration showing good cause may prescribe shorter times for the filing and service of papers than the time specified in Code of Civil Procedure Section 1005. Moreover, California Rules of Court Rules 3.1200 et sec set forth the requirements for an ex parte application, including an affirmative factual showing of irreparable harm, immediate danger, or any other statutory basis for granting relief ex parte. As stated in the Declaration of Howard E. King and other materials submitted herewith, good cause exists to enter an order shortening time to hear Warner's request for limited discovery, or in the alternative, to continue the hearing dates so that such request can be heard on regular notice. Warner will suffer immediate and irreparable harm if the request for limited discovery is not heard on shortened time and the hearings are not continued. In other words, the hearings are not delayed, including because if Warner and the court to comply with regular notice requirements of Code of Civil Procedure Section 1005B, a hearing on regular notice could not be held until after his opposition to the first motion to strike was already due. Basically saying, I should be allowed to have this ex parte hearing heard in front of the court as quickly as possible, because it's sort of like an emergency remedy, pretty much, to be able to say, like, look, judge, I need to get, your honor, I need to get my issue in front of you immediately. I recognize that normally for motions, there's this whole scheduling thing that you've got to do, and you get a hearing date that's months out, but this is much more urgent than that, and I need to have this heard ASAP. Okay. Accordingly, at the July 6th hearing, where the court advanced the hearing dates on its own motion, the court advised Warner to move ex parte to the extent he sought discovery in advance of his new August 5th opposition deadline. So, in other words, when the judge decided to, on July 6th, move the anti-SLAPP hearing up on the calendar to the left by like a few months, Warner's counsel undoubtedly opposed it, and then the judge said, "All right, file an ex parte motion or an ex parte application, and then let's hear the arguments on that date." And then there's a footnote 1. Even where a notice motion filed the day of the July 6th hearing, which, given the detailed showing required under Section 425.16G, would have been impossible, Warner still could not have completed 2-party depositions and 3 out-of-state non-party depositions, if so permitted, by August 5th, 2022. Yeah, depositions take a long time to schedule. They really do, because not only do you need the deponent to be able to be available for a half a day, an entire day, you also need to have opposing counsel be available on that day. They can't, I mean, they might have hearings, they might have trial, they might have other depositions, they might have all kinds of different things going on, that their schedule needs to be opened up. So scheduling a deposition can take more time than one would expect unless you are familiar with the process. Back to the document here. As detailed further in the discovery motion filed herewith, even when a moving anti-SLAPP defendant carries its burden to establish the causes of action, its challenges arise from enumerated protected activity. A plaintiff with non-frivolous claims can defeat the motion under the second prong of the statute's 2-prong test by showing a probability of success on the challenged claims. And it's not the highest burden, by the way. It's like they almost have to show like a scintilla of evidence, a chinchilla of evidence. While defendants seek to strike certain causes of action, including on the grounds that Warner cannot show evidence of their state of mind and intent, California law is clear that where evidence necessary to establish the plaintiff's prima facie case is in the hands of the defendant or a third party, as the case for state of mind/intent evidence, the plaintiff must be given the reasonable opportunity to obtain that evidence through discovery before the motion to strike is adjudicated upon a timely and proper showing in response to the motion to strike. In other words, they're saying, all right, there is an element that he has to prove for defamation per se and for intentional infliction of emotional distress that has to do with Evan Rachel Wood's state of mind and Illma Gore's state of mind. Of course, they are going to respond by saying, I don't have that state of mind that you are alleging. Of course, they're going to say that because that's in their best interest. So this is why courts say, all right, when you have a special motion to strike, an anti-SLAPP motion, where the plaintiff has to show a little bit of something, we've got to give them the ability to do at least a little bit of discovery to make a case. And then it cites to Lafayette Morehouse Inc. v. Chronicle Publishing Company, I think. Holding courts must liberally exercise their discretion by authorizing reasonable and specified discovery timely petitioned for by a plaintiff. In other words, saying, yeah, you got to be a little generous to the plaintiff in giving them the ability to get some information for purposes of responding to an anti-SLAPP motion. Given that Wood and Gore will submit opposition papers in advance of the ex parte hearing, the court can hear and rule on a request for limited discovery on shortened time. However, if the court would prefer to hear Warner's request for limited time and specific discovery on regular notice, he respectfully requests the August 18th and September 14th hearings be continued accordingly. While Wood and Gore have indicated they will oppose any continuance of those hearing dates, there is no prejudice to Wood or Gore, who originally noticed their hearings for December 2022 and January 2023 and did not request in advance of or at the July 6th case management conference that those dates be moved up, let alone by several months. That's not a bad point, actually, by saying that, hey, look, Wood and Gore were okay with their hearing dates being all the way in December and January. And if they had kept those on in December and January, and if the court on its own hadn't moved up the hearing dates, Brian Warner would have had plenty of time to notice these depositions that are so crucial. So there wouldn't be this major urgency to have this hearing in front of the court like the next day, this like emergency hearing. But it's been created by the fact that the court decided on its own to move up the July 6th hearing date. Or on July 6th, the court decided to move up the hearing dates, is what I meant to say. Part 3, counsel has complied with the notice requirements of California Rules of Court, Rules 3.1203 and 3.1204. Basically, I'm just going to summarize this portion. I mean, it's just a paragraph, but basically saying, yeah, we're supposed to give notice to opposing counsel so that they have enough time to show up this so quickly the next day to respond to this kind of a motion and argue their side, and we've done that. And then there's a conclusion. For the reasons set forth above, good cause exists for the court to grant the ex parte order, shortening time to hear Warner's motion to conduct limited discovery pursuant to Code of Civil Procedure Section 425.16G and request for a continuance of defendant's motion to strike to permit such limited discovery, or in the alternative, to continue the August 18th and September 13th, 2022 hearing dates so as to allow Warner's request for limited and specific discovery to be briefed and heard on regular notice. So basically, in other words, their argument was, look, we have the ability to request some amount of information, some amount of evidence from the opposing side in order to meet the burden that has been placed on the plaintiff by the anti-SLAPP motions. So because of that, when any party in litigation has a burden, they usually have, along with that, an ability to have a little bit of room, a little bit of leeway to request information to meet that burden. And this anti-SLAPP is no exception. So basically what they were saying in this as well is that they said, hey, let's have the court make a decision tomorrow on the motion for discovery requests. Let us know tomorrow, Your Honor, if we can start making discovery requests to the defendants immediately. Or if you don't want to make that, make the decision on that particular issue tomorrow, then let's at least give ourselves some breathing room to flesh out these arguments and hear more from the other side, et cetera, et cetera. Okay, that's basically the ex parte application. Now there is let me see here, I'm trying to do two things at once, and as usual, it means I am losing focus. Then we have the opposition from Evan Rachel Wood on the ex parte application here, and I will share it again. Okay. Let's see. Is this better here if I do it like this? At least for now. Yeah, actually, that is better. Okay. Defendant Evan Rachel Wood's opposition to plaintiff's ex parte application for an order shortening time to hear plaintiff's motion to conduct limited discovery pursuant to Code of Civil Procedure anti-SLAPP statute, and request for a continuance of defendant's motions to strike to permit such limited discovery. And there's a declaration attached to it. Alrighty, so you can see here their basic outline of their arguments is that there's the factual background, and then there's the reasons why they say that the ex parte application should be denied. So first off, they go through Evan Rachel Wood naming Marilyn Manson as her abuser and then him retaliating against her. These are her allegations. And then saying that after Wood files an anti-SLAPP motion, plaintiff waits months before applying for ex parte relief, basically saying, too bad, so sad, you waited too long and now it's too late. That's the argument that they were making for the ex parte application. Then they were saying the plaintiff's motion for discovery cannot be heard on an ex parte basis, basically saying you can't do this overnight because we've got to be able to really we have to have time to flesh out our opposition to this particular motion. Then they say plaintiff's request to shorten time should be denied because plaintiff's lack of diligence created the quote unquote emergency, basically saying this is your own damn fault. Plaintiff's request to continue the August 18th hearing should also be denied for reasons which we will get into in here. Alrighty, let's get into it. So as a reminder, this is filed by Evan Rachel Wood. Plaintiff Brian Warner's ex parte application to shorten time and to continue the August 18th hearing date should be denied in its entirety. This is a timing and scheduling crisis created by plaintiff's lack of diligence and failure to establish probable cause before filing this action, and defendant Evan Rachel Wood should not be prejudiced because of these failures. Incredibly, plaintiff admits that he filed this action against Wood despite the fact that he does not have enough evidence to defeat the anti-SLAPP motion. But the time for plaintiff to procure evidence and establish probable cause was before filing this lawsuit, not afterwards and in the face of an anti-SLAPP motion. I will just say that having litigated anti-SLAPP motions in California, that's not the standard. that's not the standard. You can't hold every single plaintiff to that. And to say like, no, like there's absolutely no way that for them to have any ability to get discovery because you should have done all of your research beforehand, because you could use the same logic for the lawsuit in general, right? Like we say, we in the United States, we have a very low pleading standard, basically to say that the plaintiff has a low standard in order to start the lawsuit, right? To file the lawsuit, to have the lawsuit not be thrown out at the first outset. It's a pretty low standard because the court is not going to expect the plaintiff to have all of the evidence at the very beginning. It in a lot of cases, the defense is the side that has most of the information as to what really happened. So, for example, if you have a trip and fall situation, a plaintiff needs to know what the defense was doing, like with the grocery store or whatever was doing as far as their policies for like when they were cleaning the floor, and like do they have an issue with cleaning the floors regularly? Do they let spills out all the time and let them stay there for hours and hours on end? So like that kind of information is never going to be, not never, but usually a lot of times is not going to be in the hands of the plaintiff. And their only way to get that is through the discovery process in litigation after you're already in the litigation process. So with the argument that they are making here in their opposition to the ex parte application, Evan Rachel Wood's side, I disagree with it because they're basically using that same logic, saying, no, you should have all of your information before you file a lawsuit, plaintiff. That's not gonna, that to me is not a convincing argument. So then at line 10, they go on to say, it is well established under California statutory and case law that defendants who file anti-SLAPP motions are entitled to have their motions decided promptly without being subjected to expensive and time-consuming discovery. Plaintiff's ex parte application, if granted, would eviscerate these clearly defined goals and deprive Wood, who filed her motion nearly 3 months ago, of the rights guaranteed to her under Code of Civil Procedure, Section 425.16. So it's not exactly the worst argument out there to say, look, you had 3 months. Like, where were you? Why didn't you notice these depositions before? But on the other hand, I can see the plaintiff's attorneys being like, look, we've been making phone calls. We've been making, all kinds of different outreach on this particular case, in talking to all kinds of different people and getting declarations and all this kind of stuff, and doing our side of stuff. And we, we're just now getting to it because we had the time. Like it wasn't exactly a requirement. Anyway. Um okay. Sorry. Moving on. The statute requires that a plaintiff seek discovery by way of a noticed motion. Notice motion meaning that there is a motion that's sent to them. There's enough time. There's a certain amount of time that gets provided to the other side to respond. All this kind of stuff. That's what they mean by a noticed motion, as opposed to an ex parte application where it's literally like what happens is you have a phone call in the morning from the opposing counsel where they say, "Hey, we're going to file an ex parte application so that we can have a hearing tomorrow morning in front of the judge. Is that okay with you? I'm going to send you an email confirming this conversation, et cetera, being like, just so you know, this is what's happening. And that's what happens. It's like really, really fast. And it's only supposed to be used for emergency purposes. Okay. They say at line 16, nevertheless, plaintiff asked this court to rule on plaintiff's motion for discovery at the July 22nd ex parte hearing. Plaintiff's request for an ex parte ruling where a notice motion is explicitly required demonstrates an egregious disregard for the law and Wood's due process rights. Moreover, plaintiff's request to shorten time should be denied because it deprives Wood of her statutorily prescribed time to oppose plaintiff's motion. Plaintiff waited nearly 3 months after Wood filed her anti-SLAPP motion and over 2 weeks after the court advanced the hearing date to file his motion for discovery. Had he acted diligently, there would have been no need to hear his motion on a shortened schedule. Plaintiff should not be rewarded and Wood should not be punished for plaintiff's lack of diligence. It must be established, and then it cites to Mission Power Engineering Company versus Continental CAS Company. I don't know what CAS stands for. Anyway, it must be where it says, they quote it as, it must be established that the moving party is without fault in creating the crisis that requires ex parte relief. So they're trying to say Marilyn Manson's side has created the crisis, and so they shouldn't be able to file an oopsie. Can we have more time when they were the ones that are at fault for it? I personally disagree. I think that the court created this issue by bumping up the hearings on everything at the July 6th hearing. However, I mean, they have good arguments here as to the discovery motion issue, where they say here that plaintiff's request to shorten time should be denied because it deprives Wood of her statutory prescribed time to oppose plaintiff's motion. I actually agree with that because yeah, like she should have the ability to flesh out her arguments in opposition to that. If she thinks that she shouldn't be be deposed or whatnot for this particular issue. I mean, I do agree with that specific argument. I disagree with their argument that they say that plaintiff is being rewarded for his own lack of due diligence. Finally, plaintiff asked for special treatment by seeking a continuance of the August 18th hearing on Wood's motion, even though the law requires that the motion be heard not more than 30 days after the service of the motion, unless the docket conditions of the court require a later hearing. Here, the docket conditions allow for Wood's motion to be heard on August 18th, which is still more than 3.5 months after Wood's motion was filed and more than 40 days after the court advanced the hearing date. There is no basis to delay resolution of Wood's motion simply because plaintiff wants more time to try to find evidence to support his meritless claims, something he should have done before filing this I can read, guys, this frivolous lawsuit. So in other words, I mean, that's also not a terrible argument. I don't find it convincing personally, but it's not a terrible argument to say this last paragraph, basically where they're saying that the law requires the motion be heard within 30 days after the anti-SLAPP motion is filed, unless the court is backed up for its own reasons. Or docket conditions of the court require a later hearing. However, that's not the end of the story though, because if justice would require that the plaintiff have some extra time to be able to conduct some discovery to meet the burden in order to properly respond to the motion, then yeah, he should be entitled to that. All right. Part 2, factual background. And first, Teen Tennessee, thank you so much for the super chat. Thanks for the $9.99 super chat. That's really kind of you. And I see that you're a member too. I appreciate that so much. So, alrighty. Okay. Now, back to the opposition here by Evan Rachel Wood under the factual background. So this is where she goes in and makes her case again about her side of the story, where she says, Part A, Wood names plaintiff as her abuser. Plaintiff retaliates by suing her. Wood met plaintiff in 2006 when she was just 18 years old. What started out as a seemingly loving relationship became increasingly abusive over time. During the course of their relationship, plaintiff abused Wood by, among other things, raping her, torturing her, tying her up, beating her, shocking sensitive parts of her body, threatening her life, blackmailing her, hacking into her accounts, and isolating her from friends and family. In 2010, Wood finally found the courage to leave plaintiff for good, but she did not begin speaking about the abuse she had suffered until years later. Once she opened up about her experiences, she became an advocate for survivors of domestic violence, including testifying before the U.S. Congress and California State Senate to promote legislative reforms. On February 1st, 2021, Wood publicly identified plaintiff as her abuser for the first time. Just over a year later, on March 2nd, 2022, plaintiff retaliated against Wood by filing the present lawsuit. Plaintiff filed the lawsuit less than 2 weeks before the premiere of the HBO documentary Phoenix Rising, which chronicles Wood's experience as a domestic violence survivor and activist. This timing was no accident. Plaintiff was attempting to silence Wood and the many others who have spoken out against him. Okay. Part B. After Wood files an anti-SLAPP motion, plaintiff waits months before applying for ex parte relief. On April 19th, 2022, counsel for Wood notified plaintiff's counsel that Wood intended to file an anti-SLAPP motion. Even though there is no statutory requirement to meet and confer, Wood's counsel proposed that the parties set up a time for a call. Wood's counsel provided additional detail about Wood's intended motion on the April 22nd meet and confer call. During the call, plaintiff's counsel asked whether Wood would voluntarily appear for a deposition, notwithstanding the fact that filing an anti-SLAPP motion automatically triggers a discovery stay. Wood's counsel made clear that, pursuant to the anti-SLAPP statute, plaintiff would have to seek permission from the court if he believed he needed discovery to oppose Wood's motion. That makes sense. Wood filed her anti-SLAPP motion on April 28th. Wood set the hearing for the earliest available date, which at the time was December 13th, 2022. For months after Wood filed her motion, plaintiff made no efforts to seek discovery. All right. The parties appeared for the case management conference, or the CMC, at 8:30 a.m. on July 6th. During the CMC, the court notified the parties that the hearings on defendants' anti-SLAPP motions would be advanced. In other words, they would be bumped up. This should have come as no surprise. California law requires that anti-SLAPP motions shall be scheduled by the clerk of court for a hearing not more than 30 days after the service of the motion, unless docket conditions of the court require a later hearing. The hearing on Wood's motion was set for August 18th, which is still more than 3.5 months after Wood filed her motion and 43 days after the CMC. The hearing on the anti-SLAPP motion filed by Ashley Illma Gore, which had been set for January 31st, 2023, was advanced to September 13th. Still, plaintiff did nothing. It was not until Saturday, July 16th, 10 days after the CMC, that plaintiff's counsel first emailed Wood's counsel regarding discovery, vaguely stating that plaintiff would be seeking an order to lift the discovery stay, including to allow a deposition of Evan Rachel Wood. Plaintiff's counsel asked whether Wood would sit for a deposition prior to August 5th and whether she would oppose a request to continue the August 18th hearing date. Plaintiff did not specify what other discovery he intended to seek, did not propose any time or subject matter limitations for the deposition, and did not even attempt to justify why plaintiff believes there is good cause to take Wood's deposition. Wood's counsel promptly responded that Wood would oppose the proposed motion to lift the discovery stay and any request to continue the August 18th hearing date. Wood's counsel also indicated that Wood would oppose. Sorry, guys. Wood's counsel also indicated that Wood would oppose any ex parte application to shorten time for plaintiff's motion. So interesting that they say that they wouldn't even attempt to justify why plaintiff believes there's good cause to take Wood's deposition. Because that conversation could have gone two different ways. It could have either gone that Warner's counsel says, hey, we want to take Evan Rachel Wood's deposition for purposes of the anti-SLAPP motion so that we can oppose it. And then maybe Evan Rachel Wood's attorney said, pound sand immediately without giving an opportunity for them to explain anything further. Or maybe Evan Rachel Wood's attorney said, "Well, what are the reasons for it? What's the subject matter? How are you going to limit this for purposes of an anti-SLAPP motion?" And then maybe Warner's attorney was like, "No, absolutely, I'm not going to tell you anything." I don't know. There's multiple possibilities here, right? Because it's not exactly clear from how this was drafted, which of course it's drafted by one side. They're gonna frame it in a way that sounds best for their particular case. Anyway, on Wednesday, July 20th, plaintiff's counsel provided notice that plaintiff intended to appear ex parte on Friday, July 22nd, to seek an order shortening time on a concurrently filed motion to conduct limited discovery pursuant to Code of Civil Procedure 425.16G and request for a continuance of defendant's motions to strike permit such limited discovery. In the email, plaintiff's counsel indicated that plaintiff would seek the depositions of 5 witnesses: Michelle Langer, Gore, Wood, Michelle Meyer, and Catherine McGaffigan. Plaintiff's July 20th email was the first time that plaintiff notified Wood that he would seek the depositions of Langer, Gore, Meyer, and McGaffigan. In the email, plaintiff did not propose any time or subject matter limitations for the depositions and did not explain why he believes the depositions are necessary to oppose defendant's motions or to which motion each deposition pertains. Nor did plaintiff attempt to explain his delay in seeking discovery. Rather, plaintiff's counsel simply stated that the discovery sought is necessary to allow Mr. Warner to make a prima facie showing of the causes of action challenged in defendant's motion. Yeah, again, that exchange could have gone either way, right? Similar to the phone call of like, hey, if Wood's attorney was like, well, what exactly do you need this for? And then Warner's attorney is like, no, I'm not going to tell you. Just yes or no, yes or yes. Tell me yes or yes. And then or on the opposite side of the possibility, opposite side of the coin, maybe Warner's attorney was like, hey, well, we need this for XYZ for purposes of the motion. And then Wood's attorney just responds flat out like, nope. Either one is a possibility based on the way that this is drafted. But it's also interesting to me that they say that, nor did plaintiff attempt to explain his delay in seeking discovery, which it's like they want to frame this as he has delayed seeking discovery to show that he's created his own problem here. Sorry guys, I don't mean to be yawning. It's a little bit of a later hour here. But it's a common argument, and this is why in litigation it's always best to not have too much of a gap in between when you have notice of a problem and then you start acting on that problem, or at least showing evidence to the other side that you are acting on that problem, in order to ease your position. Because otherwise they will totally try to use that what they say is a delay. They say that it's a full 10 days in between, but the other side can probably come back and say, well, in those 10 days, we were doing X, Y, and Z. Like, we weren't just sitting on our asses and just like eating bonbons and like, oh, oops, I guess we should maybe do something for that Manson case. I doubt it. my guess is they probably have some sort of justification for like what they did in those 10 days, and it probably, I don't know. That's my guess. Just having been there myself in this process. Anyway, they say plaintiff filed his ex parte application and motion for discovery after business hours on July 20th. Although plaintiff's ex parte application is fashioned as a request to shorten time, the application and proposed order do not propose a shortened briefing and hearing schedule for his motion. Rather, plaintiff improperly requests that the court hear his motion for discovery on July 22nd at the ex parte hearing. Moreover, plaintiff failed to reserve and notice a hearing date for the motion through the court reservation system. As a result, there is no noticed motion on file to advance for hearing, which is like that's like, I mean, okay, you can use that as an argument to like complain about the other side. This last sentence here about not reserving a hearing date, because like I said before, when you file a motion that you want to be heard by the court, you also have to request, you've got to reserve a date. It's like reserving a dinner date, right, at a restaurant. The court is even more exclusive. You have to reserve a particular date in order to be able to have time to hear the motion in front of the court, so that the judge can hear your arguments, hear the other side's arguments, and then basically say, okay, this is my decision. So their argument is, oh, they didn't even go through the process of reserving a hearing date. They probably didn't do that. My guess is because they were like, well, there's always a possibility that we might have this resolved tomorrow. So why would we go through this whole process of reserving a hearing date? I don't know. Whatever. It's kind of a nothing burger, to be honest. But it's at least one more thing that they can try to use to argue. So as a litigator, I don't necessarily blame that. Hey, Secret McSquirrel, thanks so much for the super chat. £2 from Secret McSquirrel. Hey, you watching? Hit that like, please. Thank you. Thank you. So yeah, if you guys are enjoying this, if you are learning something, a few things here and there, I would appreciate it if you would hit that like button. It really does help the algorithm push videos like this one out into the ether on YouTube in front of more eyeballs to see if other people are interested in hearing about these cases. Okay. Part 3, plaintiff's ex parte application should be denied. Under California Rule of Court 3.1202, to warrant ex parte relief, an applicant must make an affirmative factual showing in a declaration containing competent testimony based on personal knowledge of irreparable harm, immediate danger, or any other statutory basis for granting relief ex parte. An order upon ex parte application should only be issued in cases of emergency, which make it imperatively necessary to act at once without notice. And then it cites to Turner v. Superior Court, which says requiring bona fide emergency for an ex parte application. The quote unquote emergency cannot be a result of the party's own lack of diligence or conduct. And then they said to Mission Power Engineering Company, to obtain ex parte relief, moving party must establish that it is without fault in creating the emergency purportedly necessitating such relief. Yeah, they're trying to make this argument, but I don't blame them. It's not the worst. Like I said, it's not the world's worst argument, but it's not a winning argument in my opinion, because you can say like, oh, you guys were taking your sweet ass time. But then you can also say that the other side is like, well, we had that time. So why are we not allowed to take the time that we have, that we can reasonably see that we've been given? And also, you never argued for us to have less time. You never argued to have a hearing to have that hearing be bumped up in the first place, the anti-SLAPP hearings. So if you didn't ask for that in the first place, how is this harming you to bump it back? Probably still earlier than the original hearing date in the first place that you were okay with. So, but still, it's like I said, it's not the world's worst argument. Fun times. Thanks so much for the $5 super chat. It says glad latest in the law is back. Thank you. Yeah, I'm trying to get back into a real rhythm, having latest in the law on Thursdays, and I think I want to also maybe introduce, maybe I'll talk about this more at the end, but I also want to maybe introduce another named live stream that's like regular throughout the week on like Tuesdays or Mondays or Wednesdays or something. I don't know. Maybe probably earlier in the week since this is later in the week. But I'm going to try to think of some names for that kind of a live stream. But anyway, yes, I'm trying to have some more predictability in the schedule for you guys, so that you can start to rely on when I'm going to be showing up here on in the law tube world. Secret Rick Squirrel says Tuesday and Thursday would be good. All right. Yeah, I might do that. Okay. Part A. Plaintiff's motion for discovery cannot be heard on an ex parte basis. Plaintiff asked for the court to hear its motion for discovery at the ex parte hearing on July 22nd. The requested relief is not permitted. The anti-SLAPP statute allows the court to order specified discovery on a notice motion. Ex parte relief is not available where, as here, a notice motion is required. Plaintiff attempts to justify his improper request by misleadingly suggesting that defendants agreed to file their oppositions to plaintiff's motion for discovery prior to the ex parte hearing. That is, and then it's see plaintiff's ex parte at 6. Given that Wood and Gore will submit opposition papers in advance of the ex parte hearing, the court can hear the rule on the request for limited discovery on shortened time. That is absurd. So they are definitely not mincing words here in this particular opposition. That is absurd. Wood's counsel notified plaintiff that Wood would file a written opposition to the ex parte application to shorten time prior to the ex parte hearing. Since Wood is opposing plaintiff's application to shorten time, Wood clearly never agreed to oppose plaintiff's discovery motion prior to the ex parte hearing. I mean, that logic is a little like chicken and the egg a little bit, but I basically get what you're saying here. Because the relief plaintiff request is not permitted and plaintiff has failed to propose an alternative briefing or hearing schedule for this motion, his ex parte should be denied. Therefore, you lose entirely. Well, realistically, I mean, the way that I see this is I like I said before, I do agree that they should have time to have a notice motion, which has a normal briefing schedule where they have time to file their opposition, and then Manson gets to file his reply. So I do agree with their overall position here. But them saying that the ex parte in general should be denied. I don't know that I quite get there. Ian Kinzel, thanks so much for the $5 super chat. It says, yes, please be more reliable or else we'll feel randomly abandoned and then you'll feel guilty. And I don't like the sound of guilty bites. All right. Yeah, no, I'm definitely working on that schedule to be much more scheduled with these live streams, like I said. So I'm glad that you want to see more of that. So, alrighty. Part B now, and we're getting towards the end of this. I think so. Yeah, we are getting towards the end of this motion. Okay, part B. Plaintiff's request to shorten time should be denied because plaintiff's lack of diligence created the emergency. Plaintiff's ex parte application for a shortened hearing schedule should also be denied because it is plaintiff's own lack of diligence that has created the purported need for an expedited schedule. Plaintiff has known that Wood intended to file an anti-SLAPP motion since at least April 19th. Wood filed and served her motion on April 28th. To the extent plaintiff believed that he needed discovery to oppose Wood's motion, he had plenty of time to file a motion on normal statutory notice to seek that discovery. Instead, plaintiff did nothing for months. Indeed, after the court advanced the hearing date for Wood's anti-SLAPP motion at the July 6th CMC, plaintiff continued to delay. A week and a half passed before a plaintiff finally reached out to Wood's counsel on a Saturday. The horror. You didn't even allow them to have their weekends. Rude. Realistically, these litigators probably all work on Saturdays anyway. I know that life. To inquire whether Wood would sit for deposition and or oppose a request for continuance. Even then, however, plaintiff failed to articulate what specific discovery he intended to seek, including any time or subject matter limitations for the proposed deposition. Nor did plaintiff even attempt to explain why he purportedly needs discovery to oppose Wood's motion. So, I mean, realistically, though, like the whole point of this being like that they reached out on a Saturday. If I remember correctly, you need like 24 hours notice for an ex parte application, and so this was Saturday the 20th, and then the hearing was on the 22nd. So they actually, uh, they still met the requirement for 24 hours notice technically, if so long as you take it from that they would have read it on Monday morning, right? They would have read their email on Monday morning or gotten the message on Monday morning first thing. So the the horror of Saturdays is just kind of funny to me that they not only did they have this, with M dashes in between, but also like Saturdays italicized. Like it's absolutely brutal. um but so and the reason why that's like that I read that as so spicy is when it comes to legal filings, um usually, like, using italics, using, like, bold letters, you're supposed to use it very sparingly because it's like pounding on a table. It's the equivalent of pounding on a table in legal writing. So when when you do see italics, it's usually gonna be something that's, like, particularly emphasized. So the fact that it's like they're emphasizing this Saturday thing is just it's funny. To me, it's just absolutely funny. So, you know, the fact that they knew on the 28th that this hearing was coming up, they knew that there's a statutory requirement for, for the hearing to be within a certain amount of time. But the fact of the matter is that on April 28th, when they got the actual, when they were served with the motion, Warner's side was served with the motion on April 28th. On the first page of that motion, it shows the date of the hearing. So they could probably see that and say, okay, this hearing is not for months and months and months. We have time to respond to this. We probably have some other fires that we have to respond to in other cases, because there's always more fires in more cases in any litigation law firm. so so anyhow, alrighty. So yeah, I appreciate their ability to argue this point, but like I said, it's unpersuasive because there's no reason why they shouldn't have the ability to use the time that they are granted when they have a particular hearing date that is, noticed previously. Rather, plaintiff waited until almost 3 months after Wood filed her motion and more than 2 weeks after the CMC to file this application for emergency relief. Plaintiff's only justification for these lengthy delays is his misplaced assumption that the court would not advance the hearing dates, even though the anti-SLAPP statute requires it to do so if the court's docket allows. Plaintiff should not be rewarded for his lack of diligence by expediting his motion for discovery, and Wood should not be punished for plaintiff's lack of diligence by being denied her statutorily allotted time to oppose plaintiff's motion. This is an emergency strictly of plaintiff's own making. Ex parte relief is therefore not warranted. Alrighty. Hey, Bad Boy Oakland, thanks so much for the $2 super chat. Says, wow, it's much easier to get read on here post Depp. Right? when Depp was going on, this case was I had like almost zero capacity to get into this particular case, but now there's more time, right? So it's nice. It's nice to be able to get caught up and brought up to speed. So yeah, thanks so much for the super chat. And Disney Nerd 85, thanks so much for your super chat for $4.99. Suggestion on name for a weekly stream: Weeklybytes or bite-sized legal commentary. Weeklybytes. I like that. I'm going to write down both of those ideas. Give me just 1 second here. All right, cool. Thanks so much for the idea. And Trisha Lynn says, question, how many cases does a lawyer at the average firm handling at once? Ooh, it depends. It really depends. I mean, if I've had as little as like 6 at a time, but as many as like 10 or 12. I mean, it depends on the kind of litigation that you're doing, because some cases are a bit more uh fast in the way that they progress, so you have to like really be on top of these things, and they can be time intensive. Other times you can have more of a delay in between proceedings and things move a bit slower, so you can oftentimes handle more all at the same time. So you'll have different irons in the fire and different things. They'll be in different stages of litigation at various points in time. So yeah. But that's a good question. Also, Trisha Lynn says, I vote Weekly Bites. Nice ring to it. Kurt says, weekly stream called Let's Duel and See Who is Left. That's a proper litigation name. Patty Joe Slaw says, did anyone suggest mini bites? You know what? That's not a bad idea. Mini bites. I like that. Mini bites sounds like YouTube shorts. That does sound like YouTube shorts. That's fun. Yeah, Shireen Robson likes mini bites too. That's so funny. Oh, and Secret McSquirrel says that you DM'd me some of the other suggestions earlier in the chat. Okay, thank you. I appreciate that because I did not see those. So yes, thank you. All right, back to the opposition here, which is almost finished. Part C, plaintiff's request to continue the August 18th hearing should be denied. Wood filed her anti-SLAPP motion on April 28th and set it for hearing on the earliest available date, which was at the time was December 13th, 2022. Pursuant to the Code of Civil Procedure, an anti-SLAPP motion shall be scheduled by the clerk of the court for hearing not more than 30 days after the service of the motion, unless the docket conditions of the court require a later hearing. And then it cites to Hall v. Time Warner Inc. Anti-SLAPP statute requires the court clerk to schedule a special motion to strike for a hearing no more than 30 days, blah, 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 blah. Okay, basically stating the same thing. The fact that the court advanced the hearing date for Wood's anti-SLAPP motion should therefore have come as no surprise. To effectuate the purposes of the anti-SLAPP statute, anti-SLAPP motions are meant to be heard promptly. Because the court is available to hear Wood's motion on August 18th, which is still more than 3.5 months after Wood filed her motion and 43 days after the CMC, where the new hearing date was set, there is no basis to delay the hearing. There is no exception to the rule that anti-SLAPP hearings be set expeditiously for a plaintiff who has waited nearly 3 months after the motion is filed to seek emergency discovery, nor do the cases plaintiff cites support such relief. Indeed, none of the cases cited by plaintiff held that a plaintiff should be granted discovery to oppose an anti-SLAPP motion or permitted to the plaintiff more time to seek such discovery. And then it cites to Garment Workers v. Superior Court, holding that the trial court abuses discretion in granting discovery to a plaintiff opposing an anti-SLAPP motion in a defamation action. Schroeder v. Irvine City Council, holding that the trial court did not err by denying plaintiff's request to conduct discovery. All right. Accordingly, plaintiff's request to continue the hearing on Wood's anti-SLAPP motion should be denied. For the foregoing reasons, they say in their conclusion, Wood respectfully requests that the court deny plaintiff's ex parte application in its entirety. Yeah, I don't blame them. That's their position. So, some of their arguments are pretty good. The arguments about the motion for the discovery issue, saying no, that deserves its own hearing. You can't do that in an emergency status because we need to have time to present our arguments fully. 24 hours is not enough for us to properly brief our position on this particular issue. So no, absolutely not. I do agree with that particular argument. I think that they had a pretty good one. But then the argument saying that this is that none of the hearing dates should be moved back for this issue, and he shouldn't even be allowed to have discovery because this is his own fault. He didn't, he waited, he just, sat on his ass and ate bonbons. um, None of those are good enough reasons, in my opinion, especially where we are then talking about the interests of justice, right? Like we're talking about someone being able to put their case on. And courts, generally speaking, they don't like somebody losing because of technicalities, and especially where like they haven't actually missed any kind of a deadline. So, yeah. So anyway, now let's pull up the court's order. All righty, here we go. Superior Court of California, County of Los Angeles. We are at the Stanley Moss Courthouse, of course, July 22nd, 2022 at 8:30 a.m. The judge, Honorable Teresa A. Boudet, is the judge in this particular case. We had appearances for the plaintiff, Howard E. King, via LA Court Connect, so over the phone. Jackson S. Trugman via LA Court Connect as well. Looks like everybody was on Court Connect. For defendants, we had Margaret Ziemianek for Ashley Gore, and then Catherine Kleindienst for Evan Rachel Wood. So that is, everybody was on the phone. Makes sense. That's normal. Nature of proceedings. Hearing on ex parte application for order shortening time. The court said, the court, having read and considered all papers filed, now rules as follows. The ex parte application to ex parte application for order shortening time filed by Brian Warner, professionally known as Marilyn Manson, on July 20, 2022 is granted. The motion to conduct limited discovery is set on August 18, 2022 at 10 a.m. in Department 50. The August 18, 2022 hearing on defendant Wood's special motion to strike is continued to September 13, 2022. On the court's own motion, the hearing on special motion to strike under California Civil Procedure Section 425.16 anti-SLAPP motion, scheduled for August 18th, is continued to September 13th at 10 a.m. in Department 50 at Stanley Moss Courthouse. Plaintiff's counsel is directed to reserve the first available motion to conduct limited discovery hearing date on the court's reservation system, then contact the staff of Department 50 to advance it to August 18th. Order setting plaintiff's motion to conduct limited discovery pursuant to Code of Civil Procedure and request for continuance of defendant's motion to strike to permit such limited discovery is signed and filed this date and incorporated herein by reference. Notice is waived. Okay, so basically, all of that gobbledygook means the court said, all right, Marilyn Manson on this particular one, you win and you lose. You don't get everything that you want, because what you want is to have me decide today on that discovery motion, to decide to allow you to conduct discovery. We're not ready yet. So what we're going to do is move everything to the right. And in August, we're going to have this hearing on your discovery motion on August 18th. Everything else is pushed back by one hearing date. Call in through the reservation system and then request in, and then we'll have it advanced to August 18th. Basically, just follow the normal procedure that happens. So basically, all of that is to say that on August 18th is when we are going to be seeing the next hearing, and it's going to be on this discovery issue. So we have Brian Warner's motion on this issue with his arguments in there and his declarations, as everyone has seen all the declarations that have been filed along with it. We will be going through in another live stream. We're going to go through the anti-SLAPP motion, and we're going to, both anti-SLAPP motions. They're very similar. But we'll go through the anti-SLAPP motions in one of the subsequent videos, either by live stream or by a pre-recorded video, probably a live stream, so that it doesn't require so much editing, because it's probably going to be a long video realistically. And then in another video, we are also going to be going over the motion. And then eventually, when we get an opposition from Evan Rachel Wood and Illma Gore on that particular discovery motion, we want to see what their arguments are. Are they persuasive? Are they not persuasive? Let's see. We'll find out. So all of that will be leading up to the next hearing in August. less than a month from now. It's like 3 weeks from now. So we should be seeing that opposition relatively soon from the defendants. So I hope you guys enjoyed this. I know I did. I had fun going through it. I know it's very like procedural of like where these parties are saying like we need to have time to fight over our fights. And at a surface level that can seem very boring and procedural, but realistically, we're talking about these two sides saying, "Well, I have a right to investigate this issue further, or enough so that I can make an argument, so that I can even move forward in the next step." This is why litigation takes so long, is because you have so many of these arguments that have statutory requirements for a certain amount of time for the other side to respond, where they have to be given enough time, but they also have only a limited amount of time. And that puts pressure on one side or the other, that they have only so much time to put these arguments together and try to convince the court for their side. So that's the drama of litigation, guys. Anyway, I hope you guys enjoyed this. And if you did, I would really, really appreciate it if you would hit that like button before you head out of this video. It really does help us with the YouTube algorithm gods. And it will push more Marilyn Manson content from this particular channel out there, get more people that are interested in this particular case, and the Vanessa Bryant case, since we talked about both of them here. Having more eyeballs that are interested in those two particular cases, and bring them on over here for more updates, more analysis, going through these papers. This stuff is so fascinating to me, and I hope that it's just as fascinating for you guys as well. Anyhow, that for me will just about do it. Otherwise, thank you, viewers, for showing up. Thank you, folks, for your questions. Thanks to the mods always for marshaling good conversation within the chat. So anyway, okay, with that, I will see you guys in the next video.